as that is not that falls short of the 35 members required, the item will not be referred to the House Committee.
Questions. Question 1, Mr. Kenneth LAU. Members, please refrain from shouting. Mr. Kenneth LAU. Mr. President, in recent years, a number of development projects in the new territories have commenced one after another. Some affected villages have relayed to me that while the clearance date is drawing near, they have not been rehoused after a protracted period of time, and that the amounts of compensation that they may get are in no way sufficient for them to purchase a residence. Mr. Ray Chan. Call for quorum.
請各位議員返。
Members, please return to your seats. Mr. Kenneth LAU.
請各位
Members, please be seated. Mr. Kenneth LAU. Mr. President, which makes them feel helpless. On the other hand, the government made special compassionate arrangements several years ago for the villagers of Chuk Yuen village who were affected by the project for construction of a new boundary control point at Liantang, Hon Kwook Wai. Such arrangements include identifying an alternative site for building a new Chuk Yuen village to rehouse the indigenous villages, IVs, and allowing the non-indigenous villages, non-IVs, to build on nearby private agricultural land a two-story cottage house with a maximum area of 500 square feet per floor. In this connection, will the government inform this council, 1, in respect of each of the 3 development projects of the Kutong North and Fanling North new development areas, the Hong Shou-kyu and new development area, and the Yuen Long South development, the number of villages, IVs households and non-IVs households to be affected, as well as the projected expenditure and the actual expenditure to date on compensation and ex gratia payments. 2, whether it will review and improve the policies on compensation and rehousing in relation to development projects, and whether it will set up a dedicated fund for development projects to expedite the disbursement of compensations to affected villages. If so, of the details, if not, the reasons for that. And 3, whether it will, in relation to the ongoing and upcoming development projects, appropriately rehouse the affected villages by adopting the compassionate arrangements for Chuk Yuen village so as to maintain the cohesiveness of the affected rural communities and prevent confrontations and disputes between the government and the villages arising from development projects, thereby promoting social harmony. If so, of the details, if not, the considerations for that. Secretary for Development. Mr. President, the government strives to increase land supply. New development areas, NDAs, and extensions of new towns are very important sources of land supply in the medium and long term. Of around 220,000 housing units estimated to be completed in the medium and long term, approximately 200,000 will come from NDAs and new town extensions. My reply to Mr. Kenneth LAU's question is as follows. 1. Within the development areas of Kutong North and Fanling North NDAs and Hong Shou-kyu NDA projects, no clearance of any new territories recognized villages will be involved. According to the freezing surveys conducted by the Lands Department earlier, the estimated numbers of households and residents affected by the above-mentioned projects are about 1,500 and 4,400 respectively, and the number of households and residents affected by the Hong Shou-kyu NDA project are about 1,000 and 3,400 respectively. For the Yuen Long South development, no clearance of any new territories recognized villages will be involved within the development area of the project, according to the recommended outline development plan announced in August 2017. Since the freezing survey for Yuen Long South development has not been conducted, Lands Department does not have estimations of the number of households and residents affected at this stage. As the relevant studies, including detailed engineering design of the above 3 development projects, are still underway, the actual area of land affected by works where resumption and clearance will be necessary is still subject to verification. Given that the land resumption and clearance work has not yet commenced and the eligibility screening of households has not yet been conducted, Lands Department cannot provide specific figures of the total estimated costs and relevant expenditures of land resumption and compensation in respect of these development projects at this stage. 2. The implementation of NDAs and new towns can increase housing supply for meeting public demand for housing. Meanwhile, we will also provide appropriate compensation or rehousing arrangements for eligible residents affected by clearance. As for residents affected by NDAs and new towns, the government is fully aware of their concerns about clearance and understands that some affected clearees would like the government to consider enhancing the existing ex gratia allowance (EGA) and rehousing arrangements for land resumption clearance. As a matter of fact, in view of the importance of Kutong North, Fanling North NDAs and Hong Shou-kyu NDA projects, the government has proposed special ex gratia compensation packages and special rehousing schemes for affected eligible households. With regard to different development projects, Government departments have also all along maintained candid exchanges with district councils, stakeholders, and affected clearies through different meetings and interviews to understand their concerns. We will continue to listen to the views expressed by all parties concerned. Separately, at present, the government pays compensation for land acquisition and clearance-related allowances according to an established mechanism through the block allocations mechanism under the Capital Works Reserve Fund, CWRF. Specifically, the assessment of statutory compensation is based on the provisions under the relevant ordinances, whilst EGAs are calculated in accordance with the eligibility criteria and payment framework endorsed by the Legislative Council Finance Committee. So long as compensation and EGAs for those affected by the relevant land acquisition and clearance are assessed in accordance with the set ordinances and endorsed framework, the government will pay compensation and EGAs to those eligible under the applicable subheads created under Head 701 of the CWRF through the block vote mechanism. The said prevailing arrangement enables LegCo to endorse the eligibility criteria and payment framework of compensation and EGAs, and also allows the government to pay compensation and EGAs in a timely manner. The government currently has no plans to establish other dedicated funds apart from CWRF. 3. Chuk Yuen Village is a pre-1898 recognized village located within the Frontier Closed Area, FCA. Before the construction of Liantang Hung Yuen Wai Boundary Control Point, the indigenous villagers, IVs and non-IVs of the village have been living together there for a long time. The government has decided to provide eligible non-IVs with a special arrangement of cottage house option, whereby non-IVs may construct cottage houses on agricultural land purchased by themselves within the area. The special arrangement has taken into account the unique special circumstances of Chuk Yuen Village being located in a remote FCA, whereby the non-IVs and IVs of Chuk Yuen Village have been living together within the remote FCA for a long time, forming a closely knitted community. However, such special circumstances do not exist in the existing and upcoming development projects. Moreover, the objectives of implementing NDAs and new town extension projects are to increase land and housing supply and to unleash land potential for development of higher density housing and other development purposes through integrated planning and infrastructural upgrading. If part of the land so released is allocated for construction of two-story cottage houses for rehousing purposes, while it may be more easily acceptable by affected households, developable land in the medium and long term will be reduced and site use cannot be optimized, and the cost effectiveness of infrastructural investments will also be reduced. These may not be in the interest of society in general. In view of the shortage of land resources, we believe that the cottage house option is not a desirable rehousing arrangement. The target of the special rehousing schemes currently proposed by the government for eligible households affected by Kutong North, Fanning North NDAs and Hung Shui Kiu NDA projects is high-density, multi-story residential developments. Not only can this optimize site use, but it can also preserve past neighborhood connections as far as possible. Thank you, Mr. President. Mr. Kenneth LAU. Now, the government has included the overall planning and development strategies in the 2030 plus. According to the government, the objective is to make Hong Kong a livable city with competitiveness and sustainability. It will be a world-class city, and by development, that means households will be affected. Regardless of their status, they should be given reasonable compensation. They should be rehoused. Just like residents in Wangchao, recently, they obtained several $100,000 of compensation. And judging by modern-day present-day living standards, they can only live in subdivided units for a short time. So what's the point of the government's policy? How to make Hong Kong a livable city? I think we all have an answer. Mr. President, I understand that the government is striving to create land to have developments. However, if no proper rehousing is offered for affected households, you create a bomb in the community. So when you take forward developments in the new territories, would you engage consultants to look into different rehousing proposals so that you can include this element early on in your planning efforts, so that for residents who will be vacated from Wangzhou, compensation will be offered and help will also be offered for residents to be rehoused so as to fulfill your policy objective. Secretary. Thank you, Mr. President, and thank you, Mr. Lau, for your question. In terms of compensation and rehousing arrangements, the government has adopted a certain approach. Of course, this may be subject to different views. In short, for households affected by various development projects, if they meet the incomes and assets limits applicable to PRH applicants, they would be allocated the public housing unit. And if they meet certain requirements in terms of the structure they live in and the period they have been living there, they would be given a certain amount of compensation. And if their home is situated in some strategic development areas such as Kutong North and Fanling North NDAs, like I mentioned, they will be offered special arrangements in terms of rehousing and the amount of compensation. A more relaxed approach will be taken. So it is not the case that the government does not have any policy direction in this regard. Our work will be difficult, and we also understand that affected clearies would like to have a more generous offer. And as I mentioned before, we have been communicating with them. We understand their concerns. For example, whether in terms of compensation and rehousing arrangements, a more relaxed approach can be taken and whether the amount of compensation can be enhanced. But as I said, these are major issues, and at this juncture, it's not for me to say on behalf of the government when or how the change will be made. It has to be reasonable, and there are also other views to be considered. Assuming that the government decides to make a change, we'll definitely come to the Legislative Council. And if we decide not to make a change, we'll also explain our rationale to the public. Mr. Eddie Ju. Thank you, Mr. President. Just now, the Secretary mentioned the reasonableness of the existing mechanism. I'd like to say this to the Secretary. In terms of the affected clearies who are forced to move away from their homes is so unreasonable. You talked about the relaxed criteria under the special arrangements. There are other residents affected by government projects, such as residents in Wang Chao or other public projects. They follow the 2013 mechanism. And like Mr. Kenneth Lau said, it is so unfair that the bomb will be defused any moment. So my question is, when you are going to review the situation and standardize the compensation arrangements for affected households so that there is fairness? Secretary. From the government's perspective, in terms of policy making, like Mr. Ju said, in terms of important projects that may affect the whole territory, we do have special arrangements, such as the high-speed rail, the XRL, or the Liantang Hengyun Wai BCP. We have special arrangements. There are other public works that may involve, say, construction of roads on sewage treatment plants, and the arrangements may be different. Now, of course, we can have different views on the matter, and I can only respond to Mr. Eddie Ju's comment by saying that we note your comment, and we do have an established policy. Dr. Junis Ho. I'd like to pick up on Mr. Ju and Mr. Lau's point. I share their concerns. That is, in terms of the special compensation arrangements, in terms of compensation and rehousing, the existing approach has become out of date. The compensation amount is far from allowing residents to meet their needs, such that you see the controversy in Wang Chao incident. You have the regular mechanism, you have the special arrangements. So when should which apply? Because for the regular scheme, they are not up to standard. When are you going to review it? You should avoid ex gratia payments as much as possible, and you should give everybody equal treatment. I urge the Secretary to speed up your work and catch up with the times. Secretary, I thank Dr. Ho for his comment. I'm not going to repeat the point on when the special arrangements will be imposed. Under the current government policy, for important projects such as Kwo Tung North, Fanling North NDAs, we're going to have special arrangement for Hung Shui Kiu, likewise, and Yuen Long South development. During the consultation exercise, we already said that we'll draw reference from the Fanling North and Kwo Tung North NDAs, depending on whether the development is of the same level of importance to the whole of Hong Kong. Mr. Alice Mack. Mr. President, well, it is urgent to find land to have developments. If we have more developments in the new territories to address the housing needs of the public, it should be welcomed by the public. However, every time when you have an NDA project, you have land resumption, which affects residents living there. People have the perception that the government is evicting current residents away from their homeland. So why can't the government devise a better proposal so as to grasp this opportunity properly whilst addressing the housing needs of the general public? I noticed in part 2 of the Secretary's reply that they have an established mechanism for paying compensation for land acquisition and clearance-related allowances, and they do not have in mind a dedicated fund. Apart from Kwo Tung and Fanling North, where you have special arrangements, even if you're not going to set up a dedicated fund, will you review the existing mechanism? For example, raising the amount eligible under the EGA arrangement. Secretary. Thank you, Mr. President, and thank you, Ms. Mack, for the question. Well, for the block vote mechanism, the Finance Committee just discussed this issue, whether it's possible to make adjustments under the framework. According to my main reply, the mechanism has been operating smoothly. Now, I mentioned the block allocations mechanism and the dedicated funds. Now, from our perspective, the idea of a dedicated fund is at the moment not clear to us. And if a dedicated fund could help smooth land acquisition process, then it would be a good idea. However, it also depends on the importance of the project. Because the issue isn't raised in the question, we have not provided a reply, except that we do not have a dedicated fund in mind. As for compensation or rehousing arrangements, like I said just now, we have noted members' comments. I cannot at this juncture say whether we are going to make a change or what that change will be. But we note members' comments. Mr. Leung Yu-chung. Mr. President, in part 2 of the Secretary's reply, he said very clearly that for eligible households affected by the clearance procedure, they would be given appropriate compensation and rehousing. But as we understand, affected clearees are not happy with these arrangements, even if they are eligible, not to mention those who are not eligible. And in part 3 of the reply, the government cited Chok Yuen Village, commenting that if land is released for the cottage house option, land use cannot be optimized, and this approach, therefore, should not be taken. Mr. President, I recall in Hung Shui Kiu, there would be a block of building for decanting affected clearees. I don't know whether this is true, but it may be good news for the affected households. Instead of having cottage houses, if we have a multi-story residential building for decanting purpose, we can help address the issue. Just like affected clearings in Lam Tin in the past, the eligibility test would be spared and they would be allowed to move in the building for decanting. So, Secretary, I wonder if you would consider this. Instead of cottage houses, you will build a multi-story residential building for decanting affected clearings so that the eligibility for PRH will not be taken into account. Secretary, well, let me lay out some facts for the benefit of Mr. Leung. In terms of our housing policy, for Kwu Tung North, Fanling North, NDA, our special arrangement is, well, of course, subject to an eligibility criterion. But the housing society will be constructing a building on a piece of land for decanting. Now, according to our current arrangement, if you are a tenant, you will still be subject to the means test of the HA for PRH applicants, but it will be slightly relaxed. If you are an owner, the housing society also offered sale flats, and affected households will not be subject to any means test. For Hon Kwo NDA, as I mentioned just now, because of the progress of clearance and construction, this stage may come a bit later, but reference withdrawn to from the aforesaid project. As for Yunnan South, at the moment we do not have this special arrangement.
Question to Dr. Priscilla Leung. President, at present, applicants may only receive one of the various allowances, including old age allowance or OAA, disability allowance or DA, and old age living allowance under the Social Security Allowance Scheme. Regarding the provision of financial assistance for the elderly, will the government inform this Council, 1, whether it will consider lowering the age threshold for receiving OAA from 70 to 65 so as to alleviate the financial pressure on elderly people below 70? If so, of the details, if not, the reasons for that. 2. Of the respective numbers of elderly people aged 70 or above who received normal disability allowance or NDA and higher disability allowance in each of the past 5 years, and the annual expenditures as estimated by the government that will be incurred respectively if OAA is also disbursed to them concurrently. And 3, given that NDA is currently pitched at $1,695 per month only, but quite a number of elderly recipients of NDA are in financial straits and have to meet huge medical expenses, whether the government will enhance the financial assistance for them, such as increasing the DA level and allowing them to concurrently receive OAA, which is pitched at $1,325 per month. Secretary for Labour and Welfare. The current Social Security system, comprising the Comprehensive Social Security Assistance or CSSA scheme and the allowances under the Social Security Allowance or SSA scheme, including the old age allowance, old age living allowance, disability allowance, etc., does not require applicants' contribution and is funded by the government's general revenue, which involves substantial public funds. In view of an aging population, the government has to ensure prudent use of public funds in order to provide targeted support for needy elderly persons. My reply to the question is as follows. 1. The non-means tested OAA, currently at $1,325 per month, provides cash allowance to eligible elderly persons aged 70 or above to meet their special needs arising from old age. In the face of a growing elderly population, the number of OAA beneficiaries and public funds involved would continue to rise. According to the Census and Statistics Department's projection, excluding foreign domestic helpers, the number of elderly persons aged 70 or above would increase from about 0.77 million in 2016 by over a million to 1.86 million in 2036. In 2066, the number of elderly persons aged 70 or above is projected to reach 2.18 million, which is about 3 times of that in 2016. Having considered the sustainability of the social security system, the government has no plan to lower the age requirement of OAA. In recent years, the government implemented a number of targeted measures to support elderly persons with financial needs. For instance, the government implemented OALA currently at $2,565 per month in 2013 to supplement living expenses of elderly persons aged 65 or above with financial needs. Also, the government relaxed the asset limits under OALA on the 1st of May last year to benefit more elderly persons with financial needs. The government will also implement the higher OALA in mid-2018. It is $3,435 per month at 2017 level to provide further support for elderly persons with greater financial needs. The payment will take retrospective effect from the 1st of May 2017. And 2. DA and OAA under the SSA scheme are non-contributory and non-means tested. Their designs have taken into account the special needs of the 2 respective target groups of beneficiaries. So they should not be applied together. For instance, persons with severe disabilities, regardless of age, generally require more assistance and care from others when compared to elderly persons without disabilities, and hence the rate of DA is higher than that of OAA. Therefore, a person cannot receive both allowances concurrently. Also, such arrangement is in line with the no double benefits rule, which ensures the sustainability of the social security system. The government has no plan to change this rule. In response to the members' requests, the number of normal DA and higher DA recipients aged 70 or above in the past 5 financial years is set out in Annex. Part 3. DA is provided to persons with severe disabilities who require substantial help from others to cope with daily life so that they can meet special needs arising from their disabling conditions. The normal DA and higher DA are currently at $1,695 and $3,390 per month respectively, and are dispersed based on the recipient's disabling conditions. Elderly persons with disabilities who have financial needs may consider applying for OALA, higher OALA, which is to be implemented in mid-2018, or CSSA scheme, having regard to their circumstances and wish. In this connection, elderly persons or persons with disabilities may receive higher CSSA standard rates than able-bodied recipients based on their conditions. They are also eligible for a series of CSSA supplements and special grants. Currently, the average monthly CSSA payments for singletons with disabilities and elderly singletons are at $5,866 and $6,115 respectively. In addition to the above cash assistance, to alleviate the burden of medical expenses on elderly persons and their families, the government has lowered the eligibility age for the elderly health care voucher from 70 to 65 with effect from the 1st of July 2017. More elderly persons are therefore receiving voucher value of $2,000 a year to use private primary care services. The medical fee waiver for public health care services has also been extended to OAL recipients aged 70 or above with more financial needs. The government will continue to monitor the implementation of various measures and provide appropriate support. Dr. Priscilla LEUNG. The secretaries said they would consider. The secretary said he would not consider lowering the threshold, and I was very disappointed. As you said in your main reply, population aging is becoming more serious, even as a lot of people are retiring at 60. So elderly persons aged between 60 and 64 would not receive anything. For the $2 concessionary fare for public transport for retirees with no other sources of income, we can encourage them to go out or volunteer without paying hefty transport fees. So is this something you would consider? This would allow retirees aged 60 to 64 to take part in various activities in our community. I hope you can consider that. Secretary, as for the concessionary transport fare scheme, the government plans to commence a study shortly to evaluate the effectiveness of the scheme and to consider various recommendations. And we have nothing to add at this point. Mr. Kwong. The crux of the problem is whether the $1,325 old age allowance or fruit money would see a lowering of age threshold. And as for the healthcare voucher, we know that elderly people would receive a voucher value of $2,000 a year. For healthcare vouchers, persons aged 65 or above would be considered elderly person. But on the suggestion to lower the age threshold of OAA, you said that would not be considered. Secretary, you might be eligible for the healthcare voucher very soon, but a lot of grassroots elderly persons under 65 would like to receive OAA. So by 2036, the elderly population will reach 1.86 million. So hopefully we can lower the OAA age threshold so that people like the Secretary can receive it. The healthcare voucher system and our policy on OAA are two entirely different issues. Healthcare vouchers encourage our elderly people to use private care services, which would alleviate the burden on public health care. For the healthcare voucher scheme, we are talking about a value of $2,000 a year, and for OAA, it's $1,305 per month. So these are two entirely different policies. Mr. Siu Ka-chun. Thank you, President. In the second paragraph of the main reply, the Secretary said receiving DA and OAA at the same time would constitute double benefits and it would affect the sustainability of the social security system. I think it was certainly an overstatement. For the OAA or fruit money, the rise this year is only $20 from $1,325 to $1,345. So how can you explain yourselves to the elderly people? Would the government and Secretary consider raising the OAA level? The increase of $20 was simply a disgrace to Hong Kong. When we adjust the CSSA levels and the allowances under the SSA scheme, we have an established mechanism for adjustment based on inflation. As of figures from December 2017, by Friday, we hope to receive endorsement from the Finance Committee, and the levels would be adjusted based on inflation. And the figure we obtained, or the rise, would be 1.4%. If we translate 1.4% into actual amounts, the amounts might sound low to some members, but we must realize that our adjustments are based on inflation. So after adjustment, the levels would be comparable. Mr. Jonathan Ho, by 2066, the elderly population projected will only be 2.18 million. So we are talking about an extra expenditure of about $2 billion in OAA. So can Hong Kong really not afford such extra payment? So we were asking for an age threshold of 65 for OAA. So can you really lower the threshold so that more elderly people can receive food money? Before we had the OALA, we had the normal old age allowance for those aged 65 to 69, and there would be vetting on assets, and it would be means tested. When OALA was introduced in 2013, the criteria was the same as that for those aged 65 to 69 under OAA. So we never raised the allowance level. Decades ago, before we had the OALA, considering the average life expectancy and retirement age at that time, there were substantial differences from today, but we did not raise the threshold nonetheless. Mr. Leung Yu-chung. President, in the second part of the Secretary's reply, he said that distributing DA and OAA concurrently would constitute double benefits. And he said there should not be double benefits in order to ensure the sustainability of the social security system. I'd like the Secretary to explain what he meant by sustainability. Is it about money? Is the Secretary concerned that with double benefits there might not be enough money to cover the allowances? In the annex in 2012, in the year 2012 to 13, the total number of recipients was about 50,000, and for 2013 to 14, the total number of recipients was about 25,000. And OALA was introduced at that time, so the number of recipients dropped. For the 50 recipients in 2012 to 13, not all of them were elderly persons. So even if there were cases of double benefits and the monthly expenditure was less than $100 million, so why did the Secretary say that there would not be sustainability with such double benefits? I'd like to clarify some information. In the annex, the numbers refer to recipients aged 70 or above receiving normal disability allowance and higher disability allowance. So the number of recipients cited refer to recipients aged 70 or above. In the main reply, in the first part, I talked about the future population growth, especially the elderly population. So if we offer double benefits, this would further increase the burden on public expenditure due to population aging. Mr. Wilson-Law. Thank you, President. When Mrs. Carrie Lam ran for the chief executive, she said Hong Kong must have ample surpluses, and she talked about returning the wealth to the people. And in 2018, the utilities would the utility tariffs would increase, and everything would become more expensive. And with hefty reserves of more than $100 billion, the government should decide what to do with them. Secretary, did you conduct any public consultation on lowering the age threshold for OAA from 70 to 65 years old in order to come up with more accurate projections? The speaker is not coming through the microphone.
唔好意思，主席。政府
President, the government has no plans to change the age threshold for OAA, and therefore we are not planning on any public consultations. As for the financial position of the government, OAA is also known as fruit money, and when it was introduced decades ago, and persons reaching age 70 would be considered rather old, so it was a sign of gesture, and there were no financial considerations at the time. Mr. Michael Tian. 6 years ago, I requested the government to lower the age threshold for fruit money to 65, and there was a consensus among different camps. And I'd like to cite some figures. According to the Census and Statistics Department, the population aged 65 to 69 was 390,000, and the extra annual expenditure would only be $1.9 billion, and with healthcare voucher and the concessionary fare scheme, why are you refusing to lower the age threshold for OAA? So I have a very simple question. Are you refusing to change because you want to safeguard the government's reserves or otherwise? And in the next 20 years, the elderly population above 70 will grow by 1.1 million. So for the age bracket of 65 to 69, it would not suddenly multiply. So in the future, the extra expenditure would just be about 2 billion maximum. So is it due to a lack of funds, or have you erred in your principles? I think the figures quoted by Mr. Tian were similar. I think, as you know, the biggest age bracket in Hong Kong is 55 to 59, followed by 50 to 54, and the bracket of 65 to 69 will rise substantially 5 years later, and we have to consider all these factors.
The third oral question, Mr. Poon Siu-ping. Sorry.
For the age bracket of 69, I hope you can give some figures. What is your projection for the year 2036? Yes, figures can be provided afterwards.
The third oral question, Mr. Poon Siu-ping. President, recently a part-time athlete sought my assistance, saying that he had been selected earlier on by a National Sports Association, NSA, under the Sports Federation and Olympic Committee of Hong Kong, China, to participate as a representative of Hong Kong in a sporting event held on the mainland. But his employer, which was a Savantic organization, had refused to grant him authorized absence. As a result, he had to take annual leave in order to participate in the event. Regarding the granting of authorized absence to part-time athletes for participating as a representative of Hong Kong in sporting events, will the government inform this council, 1, whether it knows the respective numbers of national and international sporting events in the past 3 years in which various NSAs has selected Hong Kong athletes to participate, and the number of part-time athletes selected to participate in such events. 2. As regulation 1111 of the Civil Service Regulations stipulates that a civil servant who has been selected by an organization officially recognized by the government to participate as a representative of Hong Kong in a national or international sporting event may be granted authorized absence not counting as leave of the respective numbers of applications for authorized absence made and approved under such regulation in the past 3 years, together with a breakdown of such numbers by the rank, that is senior, middle, and lower, to which the civil servants belonged and their relevant percentages, if there were applications rejected, of the reasons for that, and 3, whether it will enact legislation to stipulate that where an employee has been selected by an organization officially recognized by the government to participate as a representative of Hong Kong in a national or international sporting event, his or her employer must grant him or her authorized absence so as to give recognition to athletes for their efforts in winning glory for Hong Kong and to promote sports development, if so, of the details, if not the reasons for that. The Secretary for Home Affairs. The government has been proactively promoting sports development, including formulating and implementing relevant policies, providing resources, venues, and facilities to encourage public participation in sports activities, as well as supporting the Sports Federation and Olympic Committee of Hong Kong, China, SFNOC, the Hong Kong Paralympic Committee and Sports Association for the Physically Disabled, Hong Kong PC and SAPD, National Sports Associations, NSAs, and the Hong Kong Sports Institute, Hong Kong SI, in training athletes and sending teams to participate in competitions at different levels. Having consulted the Civil Service Bureau and the Labour and Welfare Bureau, my reply to the 3 parts of the question is as follows. 1. The SFNOC is a member of the International Olympic Committee and the Olympic Council of Asia. In addition to developing local sport, promoting Olympism, and providing training programs to administrative executives, coaches, and technicians in the sports sector, the SFNOC is responsible for selecting Hong Kong athletes to compete in major international multi-sport events, such as the Olympic Games and the Asian Games. There are 79 NSAs under the SFNOC. Most of them are affiliated to their respective International Federation and Asian Federation. The NSAs officially represent Hong Kong in national and international sports competitions and are responsible for managing local activities relating to their respective sports, including the selection of athletes to participate in competitions such as World Championship and Asian Championship. The Hong Kong PC and SAPD is responsible for selecting disabled athletes to participate in competitions such as the Paralympic Games and the Asian Para Games. Hong Kong athletes take part in more than 500 mainland and overseas competitions of various sports and scales each year. Thousands of athletes are involved. The numbers of athletes participating in major national and international multi-sport events in the past 3 years are listed below for reference. First, 2016 Olympic Games. Number of full-time athletes, 37. Number of non-full-time athletes, 1. The second one, 2016 Paralympic Games. There were no full-time athletes, 24 non-full-time athletes. The third one, 2017 Asian Winter Games. 2 full-time athletes, 48 non-full-time athletes. The fourth one, 2017 National Games. 114 full-time athletes and 140 non-full-time athletes. The fifth one, 2017 Asian Indoor and Martial Arts Games. 39 full-time athletes, 31 non-full-time athletes. Under Section 1111 of the Civil Service Regulations, a head of department or head of grade may, at his or her discretion, authorize absence up to a maximum of 14 days in any period of 12 months when an officer is selected as a member or an official, for example, manager or coach of a team representing Hong Kong
in a national or international sporting event or to participate for training purposes beforehand, provided that the selection is made or confirmed by an officially recognized organization which is sponsoring the team, for example, the SFNOC. An absence authorized in this connection will not count as leave. The Home Affairs Bureau has drawn up the relevant guidelines as reference for departments and grades. They may seek HAB's advice should they have any questions in processing applications for such authorized absence. Officers selected as a member of an official or an official of a team representing Hong Kong in a national or international sporting event may apply to the individual departments or grades for such authorized absence, and a head of department or head of grade may process these cases by himself or herself under Section 1111 of the CSR. The government does not collate statistics on these cases. The number of applications for such authorized absence on which HAB's advice was sought by individual departments or grades in the past 3 years are tabulated below for reference. In 2015, 43 cases sought our advice. 34 were authorized. 9 were not recommended. In 2016, 45 cases, 35 were recommended, 10 not recommended. In 2017, 78 cases seeking our advice, 69 were recommended, 9 not recommended. The main reasons for HAB not to recommend authorization of applications were that the related sporting events were not national or international sporting events, or the applicants were not members of teams representing Hong Kong. The Employment Ordinance has prescribed the basic employment benefits to be provided by employers to their employees, including various types of leave and holidays, such as rest days, statutory holiday, and annual leave. Employees absent from work under mutual agreement with their employers would not have the continuity of their employment contracts affected by the absence. Any proposal to enhance employees' benefits through legislative means must take into account the socio-economic situation of Hong Kong and requires a consensus in the community to ensure that the proposal has suitably taken care of the interests of the employees and the affordability of the employers. The government will continue to encourage, through promotion and publicity, employers to adopt employee-oriented good personnel management practices, introduce employee-caring employment measures, and to provide employees with benefits above the statutory requirements, such as provision of special leave based on individuals' employees' needs according to their establishment's capabilities so as to attract and retain talents. Mr. Poon Siu-ping. President, I am disappointed with part 3 of the reply. Non-full-time Hong Kong athletes represent Hong Kong in sporting events and they win glory for Hong Kong, but they have to use their own money and time. There should be substantive support from the government. If you look at the past 3 years, there were 200-odd part-time athletes participating in national or international events, and there should not be a lot of impact on our economy. As for jurors, there would be authorized absence for employees to act as jurors. I'd like to know whether you will introduce similar stipulations so that non-full-time athletes can also be granted authorized absence to participate in national and international events. Secretary, part 3 of the reply is already quite clear. If we go down the legislative route to stipulate that employees and employers must relate in a certain way in this matter, this may not be entirely appropriate because, after all, we have to have a consensus in the community first. And talking about sports, actually, in Hong Kong, there are many citizens who also represent Hong Kong to express Hong Kong's image and also mission. So it may be difficult to do anything in this respect, but we are going to encourage that this be done. In fact, there are organizations in the community which provide such facility or convenience so that employees and employers can enter into tacit understanding. We'll continue to encourage this approach, hoping that employers will grant special leave for athletes or other people to help express Hong Kong's mission overseas. Mr. Hon KWOK. Thank you, President. With regard to part 3 of the reply, I'm very disappointed as well. In fact, non-full-time athletes win glory for Hong Kong, and they also have to maintain their full-time job. Their contribution is not given express recognition. The Secretary says he would rely on facilities and measures to be provided by the employers, and they are already doing their part to encourage this. But I don't think it is enough. Of course, legislation is complex, and I may not say that we should go for legislation right away. But how can encouragement be expressed? Say, for example, is it possible to do this for employers who support athletes who contribute to Hong Kong? Say, can you give some kind of support to these employers? Can there be a fund so that they can apply for it when their companies have to come under certain burden because the athletes represent Hong Kong, so as to compensate them? I don't think it will involve a big amount. Actually, for SMEs, if there is such a kind of support, I'm sure many employers would be happy to put in place such arrangement. So, Secretary, can you please let me know how you can really express and realize the kind of encouragement you have been talking about? Secretary, first of all, I'm very happy to hear from Mr. Hon KWOK that if we go down the legislative route to make specific stipulations, it may be difficult, but any kind of encouragement can be considered. Mr. Poon Siu-ping. Thank you, President. Certainly, at this stage, the administration might not want to go down the legislative route, but the fact is there is already this arrangement under the CSR. I'd like to ask the Secretary whether the CSR can also be promoted to the subvented organizations like the hospital authorities so that they can also grant authorized absence. Secretary, I think I have already answered the question, and that is any form of promotion and encouragement can be considered.
Question 4.
President, I mentioned just now, and the administration only said that it could be considered. Actually, I mentioned a fund, or you can via certain resources so that the SF and OC can manage that when athletes can apply for it on behalf of their employers so that the employers can be compensated, and so employers would be even more proactive in providing this kind of support to athletes. Secretary, I already said that in present-day Hong Kong and given the sports events, many Hong Kong athletes have won very good results for Hong Kong when they participate in events overseas. We encourage that. And as I said, Mr. Poon and Mr. Ma made proposals, and of course we have only heard them today. But in principle, we will take back these proposals for reference.
Question 4, Mr. KWOK Wai-keung. Thank you, President. At present, eligible decoration contractors, DCs, may apply to the Housing Department, HD, for being listed on the reference list of decoration contractors, the reference list. When new public housing estates or home ownership scheme courts are ready for intake, HD will select by ballot from the reference list a certain number of DCs who will be permitted to do business in such housing estates or courts. However, the tenants and property owners concerned may engage other DCs. It was reported that earlier on, the Competition Commission, had found after investigation that a number of selected DCs of a new public housing estate were allegedly engaging in anti-competitive practices of market sharing and price fixing, as indicated by the fact that the printed quotations for decoration packages provided by them looked very similar in terms of layout and prices. The Commission therefore commenced legal proceedings against them. In this connection, will the government inform this Council, 1, whether it has put in place standing measures such as regular and surprise inspections to check if the selected DCs have engaged in anti-competitive practices, if so, of the details, if not, the reasons for that. 2. Of the number of details of the complaints received by the authorities in the past 3 years about DCs on the reference list allegedly engaging in anti-competitive practices, such as market sharing and price fixing, and the follow-up actions taken. And 3. Of the justifications for selecting by ballot a small number of DCs who will be permitted to do business in new housing estates and courts that are ready for intake, which has resulted in reduced competition. Whether it has consulted the Commission on guarding against the selected DCs engaging in anti-competitive practices, if so, of the details, if not, the reasons for that. Secretary for Transport and Housing. President, my reply to various parts of the question raised by Mr. KWOK Wai-keung is as follows. On the first part of the question, according to the regulations of the Hong Kong Housing Authority (HA), residents in newly completed public housing, including public rental housing and subsidized sale flats, are required to submit applications before commencing decoration works. During the period of flat intake and conducting of the decoration works, HA staff would inspect flats under decoration. If any decoration contractor, DC, is found to have breached the laws, including the Competition Ordinance, CO, the staff member will report such acts to the relevant law enforcement department or authority for follow-up as appropriate. If any DC is confirmed to have contravened the laws, HA would take appropriate regulatory measures, including issue of warnings, suspending the licenses or agreements of the contractor to undertake decoration works in estate or courts, or even removing it from the reference list of DC. In the past 3 years, the Housing Department has not received any complaints against DCs on the reference list in estates or courts or for suspected anti-competitive behavior such as market sharing and price fixing. Regarding the second part of the question, according to the Competition Commission (CC), the first conduct rule set out in the CO has stipulated that an undertaking must not make or give effect to an agreement of which the object or effect is to prevent, restrict, or distort competition in Hong Kong. Under the CO, market sharing and price fixing are serious anti-competitive behavior. CC will handle cases involving this behavior with high priority. In fact, since the full implementation of the CO in December 2015, CC has received a total of over 2,600 inquiries and complaints. Among them, 60% were related to First Conduct Rule. Concerted behavior involving market sharing and price fixing was one of the prime concerns. For inquiries and complaints on market sharing, the three industries with the highest number of cases were estate agents and property management, machinery and equipment, as well as telecommunications. In August 2017, CC lodged a case on market sharing and price fixing to the Competition Tribunal, alleging 10 building works companies to have been involved in market sharing and price fixing activities while providing decoration service in a public housing estate in Hong Kong. The actual hearing of the said case is scheduled for November 2018. Regarding the third part of the question, having taken into account various factors, HA considered it necessary to set up the reference list of DC system. The reasons include: 1. Before the setup of the system, DCs of varying quality flocked to the newly completed estates or courts to scramble for jobs, decoration jobs, and cause disturbances to the residents. 2. Some contractors with unsound financial backing were not able to complete the decoration works and caused the residents to suffer financial loss. And 3. Some contractors aimed to maximize profits and induced residents to demolish substantial fixed fittings in the flats, thus causing damages to the structure of the flats. To address the above problems, the HA has established a set of registration eligibility criteria through the reference list of DC system. Only decoration companies fulfilling the entrepreneurial, technical, and financial assessment, as well as passing a checking conducted by the police, can be included in the list. While implementing the reference list of DC system, HA has made clear to the DCs on the list that they do not have exclusive rights to carry out decoration works in public housing. HA has also made clear to the residents that the DCs on the reference list do not have such exclusive rights to carry out decoration works in public housing. Residents can choose their own way of decorating their flats, including conducting the works by themselves or assisted by relatives or friends, or engaging other decoration companies in the market to carry out the works. HA has all along been liaising with the reference organizations on the implications of the reference list of DC system on competition. Recently, after consulting CC, HA has sent letters to all companies on the reference list to solemnly remind them to comply with HA's requirements and the laws and regulations of Hong Kong, including the CO. HA has also posted notices at new estates or courts to further remind the residents that they could choose their own DCs, and the HA also informed residents of the CO. To further protect residents who have newly taken up their flats and prevent anti-competitive behavior, HA invited representatives of CC in September 2017 to brief them on the CO. So DC in new estates are reminded not to be involved in activities involving market pricing or market sharing or price fixing. In addition, HA has in 2017 revised the decoration handbooks which are delivered during flat intake, the video clips which are broadcast at the intake briefing sessions, and the decoration undertakings which are to be signed by residents, to further remind those who have newly taken up their flats that they can make their own decoration arrangements and are free to choose their DCs. Residents who suspect that any DCs are involved in activities in contravention of the CO can report to CC directly or contact the estate or court office for referring to CC. We believe that through the above enhanced measures, residents who have newly taken up their flats and DCs would have a more thorough understanding on the CO, which may help residents to prevent anti-competitive behavior, protect their interests, and prevent DCs from conducting anti-competitive behavior. HA will continue to pay attention to the operation of the reference list of DC and views expressed by stakeholders and conduct review and follow-up action in a timely manner. Taking the case of the 10 building works companies being suspected of contravening the COs as an example, HA has conducted a review immediately and decided that before the completion of the legal proceedings, HA would stop arranging for these contractors to be stationed in estates or courts and revoke their license or agreements for undertaking decoration works in other estates or courts. After the completion of the trial, HA will make reference to the ruling of the Competition Tribunal and take appropriate follow-up actions. Mr. KWOK Wai-keung. Thank you, President. In the first part, a paragraph of the Ring reply, the Secretary said that inspections have been carried out, but they have not found any problems, and there's been no complaint in the past 3 years either. But it so happens that we only have one or two decoration contractors all along working in these estates. So that means the HA is not sensitive enough in guarding against anti-competitive behavior. It also doesn't know enough about it. Now, it's the HA that has to take responsibility. Now, when the residents try to source contractors, they are always the same ones, and the stores there stationed at the estate, and then they also quote the same price. So it seems that these contractors are just sharing out the work among themselves, and they have prices higher than the market rate under the HA system. So the HA is the culprit for institutionalizing such anti-competitive behavior. So when is HA going to carry out reform on the system and stop such anti-competitive behavior in HA estates? This is where there's a concentration of such behavior. Secretary, thank you for the question. The reference list system, let me explain why it came about. For this reference list, it started in 1982. At the time, it was meant to protect the interests of tenants and owners, because at the time there was a lot of nuisance calls and even illegal activities conducted, and some owners suffered undue loss. At that time, the system was called the Accredited Decoration Contractor System, but in keeping with the times, we eventually renamed the system to the Reference List of Decoration Contractors. The last review was in August 2015. During the review, we referred to changes in relevant legislation and regulations. We've also made reference to the views of the Competition Commission. It's exactly because of the on-tech estate case recently, we've enhanced our communication with the CC. The CC staff also gave a briefing to contractors on the competition ordinance, and in the intake manual for residents, we also explained to them clearly that they are free to choose their own decoration contractors. Yes, we know that if we prepare a list of contractors, people may have different views about competition, but the initial intention or the original intention of the list was to protect the interest of the residents, but we'll wait for the completion of the trial and then review the whole system. Mr. KWOK Wai-keung, which part of your question has not been answered, please? Sorry, speaker's not coming through. Sorry, the speaker's not coming through. Okay, you've pointed out that part of question. Secretary, anything to add, please? If I may, I'd like to thank Mr. Kwok for his question. I wanted to explain why we set up the list in the first place. It was really to guard against illegal activities. Also, we wanted to make sure that the decorators would fulfill the technical, financial, and entrepreneurial requirements. This is for the protection of residents. Now, as I said, after the competition tribunal has completed this case, we will refer to the rulings and then review our system accordingly. Ms. Yong Ho-yen. Well, I think the HA has duty to monitor the decoration contractors. Now, for the August 2017 case, from press report, we learned that the HA wasn't the party to report the case. In the last paragraph of the main reply, it said that the HA has already reviewed that case, and then it's decided that before the completion of legal proceedings, HA will stop will revoke the license agreements for these decorators. Are you going to do so after the completion of the case, or are you going to take these 10 companies out of the reference list now? Secretary, thank you, Ms. Young, for your question and comments. For the 10 contractors, they face prosecutions by the Competition Commission, and before the completion of legal proceedings, we will stop arranging for them to be stationed in estates and courts, and we revoke their license or agreements for undertaking decoration works in estates and courts too. Mr. Leung Chi-chung. Decoration works in new housing estates, that's large and profitable business. Now, even if contractors are not on the reference list, they try to solicit customers on these premises because this is really profitable. Now, if then there are contractors put on the reference list and then they collude to fix prices, of course, that would be a serious problem. That's why the HA must handle the arrangement with great care. It has to step up monitoring as well. But then under the system, the housing department has no power to monitor or regulate the decoration costs because it's an agreement between the contractors and residents. But then the decorators often offer the so-called package to make it easy for residents to make a choice. So apart from assessing the eligibility of contractors, shouldn't the housing department also consider monitoring the prices? Secretary, thank you for your question, and your comment is a very valid point. Now we adopt a risk management approach because we want to protect the interests of residents. At the same time, we want to make sure there's open competition in the market. We want to do something about that. So when the competition tribunal has made a ruling, we'll refer to the ruling, and then we will reform the system. It's hoped that in the system we are able to ensure there is open competition. And we hope that with open competition, the tenants or owners would benefit. Mr. Wilson, well, this is wishful thinking on the part of the Secretary. From what he said now, he said he wants to protect the interests of residents, but from the estate case we see is the tenants and owners who suffer the most. Now you said the reference list was launched in 1985, and then in 2013 and 2015 the list was reviewed. Could you give us more information, please? In the two review exercises, especially for the 2015 review exercise, what improvement measures were taken to make sure that the reference list of the decoration contractors is in keeping with the times? Secretary. Thank you, Mr. O, for your question. The system was first set up to protect the rights and interests of residents, because at the time there were a lot of illegal activities and a lot of disturbance was caused to the residents. And then in 2015 we reviewed the reference list, and we put in place a number of improvement measures, mainly in three aspects. One, we want to make sure there's an open market. So at the HA station and on site, we make open invitation for people to apply to join the list. And also we've increased the amount of the security to be placed. And then we have enhanced the appraisal assessment system of the performance of contractors. We adopted more objective standards for the assessment. We've also referred to the CPI index, and then for the financial assets of decorators has been increased from $1.5 million to $2.4 million. And then for the bond, it's been increased from $500,000 to $700,000. And contractors has to take out accident insurance for the amount of $20 million. So we have taken various enhancement measures to make sure we could protect the interests of residents. Thank you.
Fifth question, the Honorable Ronnie Chen. President, on the 29th of September last year, the Hong Kong Monetary Authority, Hong Kong MA, announced 7 initiatives to prepare Hong Kong to move into a new era of smart banking. One of the initiatives is a faster payment system, FPS, to be launched in late September this year. The Chief Executive of Hong Kong MA said on the same day that FPS will be a core real-time payment platform, providing customers with round-the-clock, interbank, all year-round, and real-time fund transfer services. This platform, which will be open to all banks and operators of stored value facilities, will enable real-time transactions at real-time level and provide full connectivity for the various types of operators. And by then, Hong Kong will become one of the few leading regions in the international arena in this aspect. Furthermore, for the purpose of encouraging and facilitating more small merchants to accept mobile payments, Hong Kong MA is actively discussing with the industry the development of a common QR code standard which will enable merchants to connect to the payment systems of different operators by only displaying a single QR code. In this connection, will the government inform this council whether 1. Hong Kong MA has said in respect of the launch of FPS-specific strategies, work plans, and market share targets for the next few years? If so, of the details, if not, the reasons for that. Secondly, It has plans to join FPS as an independent entity and takes the lead in making full use of a common QR code to collect taxes and various types of license fees and fines. If so, of the details, if not, the reasons for that. And 3, it has plans to make a mandatory requirement for various public transport operators as well as chains, supermarkets, and convenience stores to fully accept common QR code payments. If so, of the details, if not, the reasons for that. Secretary for Financial Services and the Treasury. President, the Hong Kong MA is working with the industry to develop FPS, faster payment system. As a new financial infrastructure, the FPS will provide full connectivity between banks and stored value facility or SVF operators. Through the FPS, participating banks and SVF operators can provide real-time credit transfer and real-time direct debit services to facilitate payments between merchants and customers, as well as peer-to-peer fund transfers. The Hong Kong MA expects to launch the FPS in September this year, and major retail banks and SVF operators have indicated their interest to participate. As for the settlements between merchants and banks or SVF operators, those are commercial arrangements and do not necessarily take place in real time. 2. Banks and SVF operators can make use of the FPS to provide various kinds of payment services and products. The government can make use of these payment services and products provided by banks and SVF operators and does not need to participate in the FPS directly. We note that the e-wallets offered by some SVF operators are providing bill payment service. Users can scan the barcodes on the bills, such as phone bills and town gas bills, and make payments through the e-wallets on their mobile phones. To facilitate the development of the SVF market, the Financial Services and the Treasury Bureau is exploring with a number of government departments on a pilot scheme under which the public can pay government bills in this manner. 3. We note that a number of SVF operators are providing and promoting QR code payments in Hong Kong. Their services have expanded to some chain supermarkets, convenience stores, wet markets, and taxis. To promote wider adoption of mobile retail payments as well as provide greater convenience to both merchants and customers, the Hong Kong MA and the industry have established a working group on common QR code standard for retail payments. The working group will explore how to enable merchants to use a single QR code to accept payments from different SVFs. Regarding payments for public transport, the Transport and Housing Bureau welcomes the introduction of new technology to facilitate fare collection in the public transport sector. At the same time, THB will need to ensure that any electronic payment system to be adopted in the public transport sector for fare collection shall be reliable, user-friendly, and efficient, and will not cause disruption to the operation of the public transport and the road or traffic conditions so as to protect the interests of passengers and road users. TD issued guidelines on the introduction of a new electronic payment system for the collection of fares in the public transport sector in June last year. TD will continue to facilitate public transport operator plans in introducing new electronic payment systems for public transport fare collection, having regard to the system's reliability, user-friendliness, and efficiency. We would also like to point out that Hong Kong has a well-developed and mature electronic payment ecosystem. Various electronic payment means, including conventional and contactless credit cards, Octopus, and EPS, have long been available and are widely adopted by the public for making payments. Electronic payment now accounts for about 60% of the total private consumption expenditure. QR code payment is only one of the various payment means, and its development in Hong Kong is still at an early stage. We believe merchants will take into account their own circumstances, scenarios of use, customer behavior, operating costs, etc., in choosing the payment solutions which would best suit their purposes. Hong Kong MA will continue to work with the industry to promote a wide adoption of QR code payment on a level playing field so as to let customers enjoy the benefits and convenience brought about by financial technologies. Thank you. Mr. Wan Chen. President, with the operation of FPS, according to its features, I believe the use of cash will reduce. I'd like to ask whether Hong Kong MA has assessed the reduction in the liquidity of cash in Hong Kong. And will there be any corresponding adjustment in the number of counters and ATM machines in Hong Kong? Thank you. We promote diversity of convenient and reliable e-payment system. We should also have regard to the behavior of our customers. As I said, about 60% of our total private consumption expenditure is made by electronic payment. Now, if we take the promotion of QR code payment as an example, at its initial stage, its impact on the use of cash would not be significant. And we will take note of further development in e-payment and the customer behavior, and we'll see whether there's any impact on liquidity or the cash flow in the market, and we'll make corresponding changes. Mr. Christopher Zhou, President, I believe many members of the public share my expectation that FPS can be introduced ASAP so that our fintech can make real progress. By then, all people need is a mobile phone, and then they can settle payments with banks and at retail level, and also at peer-to-peer fund transfer level. And e-payment means will become more and more common. In view of the vibrant stock market, I'd like to know whether the FPS can be used for settlement of stock transactions. And because the volume, the amount of stock transaction is quite substantial, would there be any limit on the amount that can be handled? And would this be recommended to the Hong Kong, the SFS, to get its approval so that stock transactions can be more convenient, and that can also help to lower the operating costs of brokerages? Thank you. I thank Mr. Chen for his interest in the use of FPS or electronic means of payment in the stock market, but the transaction amount is usually not too high. For instance, take the main as example. In the past, there was no limitation at all, and now they because of money laundering and also counter-terrorist concerns, they have lower the amount of each transaction, the limit of each transaction. So in Hong Kong now, I think the limit would only be minimum, and if we consider stock transactions, we'll talk about tens of thousands of dollars per transaction. So payment means may not be appropriate. All right, we talked about QR code and other SVR, but when it comes to e-wallets and e-checks, they can be used for settling stock transactions. Town gas bills and phone bills and some government bills do provide a barcode for settlement. So it is not necessary to use an SVF, but you can use other forms of payment means to settle bills, such as the scanning of barcodes. So if brokerages have got barcodes on their bills. Perhaps the e-wallets can also be used. Mr. Friction, octopus used to be quite common, but I think we have been overtaken by QR code settlement systems from the mainland, so we have lagged behind. I hope that the new FPS can be launched ASAP. I welcome it. And it is said that some people would like to make it a mandatory requirement for retail outlets to adopt QR code payments. But Hong Kong is a free market. I think the most important thing is support of the retail sector. As a representative of the sector, Hong Kong MA has never approached me. So I'd like to know whether you are going to communicate with players of the sector. Mr. Ediju, what is your question? Hang on, Secretary. Call for quorum, please.
局長。
Secretary.
President, Mr. Siu was talking about the use of hang on. President, just now Mr. Siu talked about the use of barcodes and also consultation of retail outlets. Hong Kong MA is not at the stage of discussing merchant acquisition. Rather, we talk about the common QR code standard and also its functional specifications. A working group has been set up to consider the standards and credit card organization, banks, SVR operators, and also service providers of merchants are involved. So they'll talk about the common standards for QR code. Mr. Siu, is aware of stakeholders who are interested to participate, please let Hong Kong men know, and then we'll give them due participation opportunity. Mr. Siu, speaker is off mic. Have you won your microphone, Mr. Siu Kafai? Speaker is off mic. Speaker is off mic. Mr. Siu Kafai. Speaker is off mic. The most important thing, the most important party is the frontline retail merchants. I hope you can take the opportunity to enhance communication with them. I have nothing more to add. Point noted. Mr. Yu Si-wing. Hello. FPS can provide convenience to the public, and it should also provide convenience to tourists, so that FPS can make Hong Kong one of the leader in this aspect. In point 3 of the reply, the Secretary said that Hong Kong MA has started a working group on common QR code standard to facilitate both merchants and customers, so that merchants can use a single QR code to accept payments from different SVFs. I'd like to know whether the working group would cover visiting tourists, because many tourists are very accustomed to using electronic means of payment. I'd like to know whether there is any plan to do so. If not, why not? Thank you. For the common standards for QR code, let me explain. Whether it be overseas or Hong Kong, different SVF operators or payment operators have different QR codes. So take one merchant as example. If it has to accept 3 different operators, there will be 3 QR codes. So a customer will have to find the right QR code to make use of his payment system. We want to offer convenience to local shoppers and also visitors to Hong Kong. So we are discussing with operators. Overseas operators have got SVF license in Hong Kong as well. So our discussion with them is to ensure that we have a common QR code standard in Hong Kong, so that when a merchant can have its own QR code, so that when a customer make a payment at a certain merchant, regardless of the SVF he uses, he can use the same QR code. This will offer convenience. We are discussing with SVF operators, and we have covered major overseas SVF operators too. So surely visitors to Hong Kong will be covered. Mr. Charles Mok. In late June last year, the TD issued guidelines on the introduction of a new electronic payment system for the collection of fares in the public transport sector. I'd like to know whether there is the competition aspect in these guidelines, because the subsidy transport fare subsidy system offered by the government only uses octopus. So people say that we are backward in this regard because octopus is too common and too convenient in Hong Kong. All right. This 1% of the subsidy will go to the companies. So $23 million will go to one facility only. While you have talked about various forms of payment being used by members of the public, I don't know whether you're aware of that. Perhaps this is a matter for the TD, but I'd like to ask the Treasury, the Secretary, whether you have asked your government departments, including the Treasury and also the government departments, to ensure that such a subsidy must support more than one SVF, not just one. And the TD or THB should reconsider its subsidy scheme to public transport systems to ensure that other SVF can be covered. Secretary, yes, although this is the THB's scope, let me supplement here. When the scheme was introduced, we chose octopus because minibuses and also residential development services were mainly using octopus. The platform is open, so the TD has discussed with different SVF operators. They have discussed with various public transport operators, including bus companies. Under the pilot scheme, they are trying out SVFs other than octopus card. But before SVFs other than octopus card is prevalent in Hong Kong, octopus card is the most common in Hong Kong. On average, a resident will have 2 to 3 octopus cards. As regards to e-bills of government, will we open up to more SVF operators for them to use? We are now exactly considering this issue. We understand members' concern, and that is we should make the scope as wide as possible. But if SVF is used for making payments, a charge is usually levied. There are different SVF operators in the market, and the levels of fees are different. The government is using public money, and therefore we must have a comprehensive plan. When different operators allow the SVF to be used for paying government bills, we have to ensure that the service charges are reasonable and appropriate. It is our intention to open up to more SVF operators subject to a reasonable fee, because if the relevant service charges are very expensive, there will be an impact on our public money.
Last question seeking an oral reply. Dr. LO Wai-kwok. Mr. Raymond Chan, call for quorum.
陆委國議員。
Dr. LO Wai-kwok. President, some professionals have pointed out that the government proposed as early as in 2014 an information technology strategy with the theme Smarter Hong Kong, Smarter Living, but the progress was rather slow. Not until last month did the government release the Smart City Blueprint for Hong Kong, mapping out the development plans in the next 5 years. In this connection, will the government inform this council? 1. Given that the Planning Department made public in March last year the Territorial Population and Employment Data Matrix, TPEDM, for reference of the relevant professional sectors in conducting technical assessments, but the aggregated data of 26 larger districts rather than the data of 454 small districts were released, rendering the relevant sectors being unable to make full use of those data. Whether the authorities will examine how to share those data more effectively with the relevant professions in the long run and consider afresh publishing TPEDM data by small district, as well as require various government departments to adopt machine-readable formats when publishing data in future so as to facilitate application developers and relevant sectors in using the data, if so, of the details, if not, the reasons for that. 2. Apart from implementing the Energizing Kowloon East project, whether the authorities will expedite the implementation in new development areas such as Hong Shui-kyu, Tung Chung East and Tung Chung West of various smart city-related proposals, including conducting planning for infrastructure such as communications, pipe networks, smart homes and green architecture, as well as making proper planning on transport, healthcare, environmental protection, elderly services, etc., by using innovative technologies and big data to strive to create a green and low-carbon smart community, if so, of the details, if not, the reasons for that. And 3, as the authorities proposed in the 2016 policy address that the number of Wi-Fi hotspots under Wi-Fi.hk be doubled to 34,000 within 3 years. Of the progress of such work so far, whether the authorities will review the target and expedite the installation of Wi-Fi hotspots and further raise the internet access speeds of Wi-Fi hotspots at busy locations so as to enable members of the public to truly enjoy free Wi-Fi service, if so, of the details, if not, the reasons for that. Secretary for Innovation and Technology. Thank you, President. The government actively promotes smart city development. We published the Smart City Blueprint for Hong Kong on the 15th of December 2017, outlining the government's vision and mission to build Hong Kong into a leading smart city of the world, and development plans in the next 5 years, covering 6 major areas, namely smart mobility, smart living, smart environment, smart people, smart government, and smart economy, including open data, developing common special data infrastructure, CSDI, 3D digital map, increasing the number of public Wi-Fi hotspots. In consultation with the Development Bureau, our reply to various parts of the question is as follows. 1. The TPEDM is updated by the Planning Department every 2 to 3 years, with data demarcated into 455 planning data zones, PDZs. TPEDM is mainly used by the government internally for the long-term and strategic land use and infrastructure planning. To respond to the requests of the public, including those of the relevant professions, Planning Department has since March 2017 published TPEDM data, which are aggregated into 26 larger planning data districts. In considering the dissemination of data, the Planning Department had consulted departments responsible for vetting the technical assessments of various private projects. These departments considered that data aggregated into 26 larger PDDs would suffice for facilitating the industry to conduct technical assessments. Besides, TPEDM contains certain assumptions for development projects which are very preliminary and still subject to studies. The relevant data are not only sensitive, but also subject to changes along the time. Further, publishing data in PDZs may disclose such sensitive information, thereby leading to unnecessary misunderstanding in the public. Planning Department considers that the current arrangement has struck a right balance between the industry's request for open data and avoiding disclosure of sensitive information. In any case, the Planning Department is now updating PTPEDM with regard to the population projection published by the Census and Statistics Department in September 2017. To facilitate the industry's usage, the Plan D will consider publishing more detailed data in machine-readable format. Regarding the format of open data, the Office of the Government Chief Information Officer has issued guidelines to assist bureaus and departments in releasing data in the most suitable formats and ways. For example, through application programming interfaces according to the nature of different data in order to make it convenient for public use. In response to the guidelines, the bureaus and departments have generally been releasing data in machine-readable formats, except information that has to be released in image format, for example, traffic snapshots. As of December 2017, there were over 3,100 various data sets under the public sector information portal, of which over 2,000 data sets are in machine-readable formats. The portal also provides over 1,000 APIs for software developers to extract the information required from the large amount of information therein. 2. The blueprint published by the government proposes using innovation and technology, including big data analytics, artificial intelligence, Internet of Things, sensors, etc., to build Hong Kong into a smart city through introducing measures in different areas, including transport, health, environment, and education. From the land and infrastructure planning perspective, we would also need a new way of thinking to cope with growth and enhance livability, as well as to strengthen our city's overall competitiveness. As such, Hong Kong 2030 Plus recommends a city strategy based on smart, green, and resilient principles to be applied across different levels of planning, including planning for new development areas. Besides, in planning for NDAs, the Planning Department will, from the planning studies stage, make reference to the blueprint and liaise with relevant bureaus and departments with a view to including suitable measures in the planning of the NDAs. During the planning and design stages of the NDN and new town extension projects being developed by the government, we have already explored introducing elements of a smart and green community and reserve land for related implementation. Our proposals mainly cover the following 4 aspects. Firstly, we will reserve space in the NDAs for provision of smart city facilities such as smart lampposts, smart rubbish and recyclables collection bins. Secondly, on mobility, the government will plan for compact development with public transport to serve as the backbone for the communities. Comprehensive, convenient, and attractive cycling and pedestrian networks will be provided for leisure and commuting purposes. Thirdly, for public services, the relevant departments will examine the feasibility of water supply system that can reuse rainwater and recycled water. To reduce the energy consumption of the areas, provision of district cooling system will be explored. Lastly, we will revitalize river channels and coastline to conserve the environment and ecology and also promote a water-friendly culture. 3. In May 2016, the Finance Committee of the Legislative Council approved a funding commitment of $500 million to implement the Wi-Fi Connected City program to provide free Wi-Fi service at more government and other venues, with a target of doubling the number of hotspots to 34,000 by 2019. As of December 2017, the number of Wi-Fi.hk hotspots has exceeded 20,300. We will review the implementation progress at the appropriate juncture and, if necessary, adjust the implementation details and consider other ways to enhance the growth of Wi-Fi hotspots with a view to achieve the target prescribed. As for connection speed, at present, the average connection speed of Wi-Fi service amidst government venues and venues operated by public and private organizations under the program reaches 3 to 4 Mbps, which is sufficient for supporting general internet services, such as web browsing, using social media, instant messaging, sending and receiving email and watching video, etc. The average connection speed of free Wi-Fi services provided through the public-private collaboration model can even reach 8 Mbps. With the continuous development of the Wi-Fi technology, we will generally adopt the latest Wi-Fi standard to reduce signal interference and improve data transfer speed and stability. We will also request contractors to use fiber links where feasible to provide the public and tourists with faster and more stable Wi-Fi services. Thank you, President. Dr. LO Wai-kwok. Sorry, the speaker's off mic. Well, we were talking about the smart city blueprint, and it covers smart mobility, smart living, smart environment, smart people, smart government, and smart economy. 6 areas are covered. That's reasonable. Smart city should cover a wide scope. And because of this, the task cannot be handled by the ITB alone. It cannot work on its own. It needs the support from other bureaus and departments. As stated my question, the ITB could only give us a reply after consulting the Development Bureau. So I would have a question for the SIT. In taking forward smart city development, how can the ITB play a coordinating role, and how can it promote the initiative so that the public can rest assured that once, since we have the ITB, then we can take forward building a smart city in Hong Kong. Secretary, thank you, Dr. Low, for your question. As we all know, we would be promoting smart development. We have established a steering committee on innovation and technology, chaired by the chief executive. And we hope that such an approach can show to the public the government's determination to pull all boroughs in. Well, we have 10 boroughs being represented on the steering committee, and also the 3 secretaries of department are also being members. So this is not purely a matter of coordination. This is a top-down and also bottom-up approach, and we are doing it in a comprehensive manner. Now, the ITB has to work together with other bureaus, and at the same time, in terms of innovation and technology, we will make suggestions or proposals using the latest technology to promote Hong Kong's smart city development. Technology develops in leaps and bounds, and it comes with both positive and negative impact. So the ITB will help deliver the relevant messages to all the boroughs and government departments. And we want to catch up fast. And we've been lagging behind all along. We want to introduce changes. Mr. Jeremy Tam. Please continue, Madam Deputy. When we talk about smart city, one thing which is very important is dissemination of data. You said that you would be publishing more data in machine-readable formats, but I don't see how you use such data to for developing transport system. In overseas jurisdictions, they would combine public transport usage together with data publishing. The data will show exactly the speed of vehicles and showing locations where vehicles should stop suddenly, and also whether the data will show the vacancy of on-street car parks, and also they will show information on the congestion on certain lanes on the carriageways, so that the transport network can be improved and problems can be anticipated. So, Secretary, how are you going to take forward initiatives on that front? Thank you, Member, for your question. The ITB has published this smart city blueprint. We can take forward three things immediately. First is we can establish a big data analytics platform. Well, we have to analyze the data before they can be put to good use. So we hope that through this platform, the different government departments can understand the value of the data they collect and how the data can be best used to draw up good policies. So that's one thing that we can do. And just now, I was also talking about technology developing in leaps and bounds. So the IDB will watch closely the development of technology, and we will try to make the best use of the latest technology and help government departments to implement their policies more effectively. Mr. Jeremy Tam, which part of your question has he not answered? So, well, the technical staff, please understand why the mics are not working so well today. Please continue. Sorry, the speaker is off mic. Yes. Well, please continue. Madam Chair, 1, 2, 3. Mr. Jeremy Tam. Well, which part of your question has he not answered? My question has been very clear. I was talking about trying to integrate big data with improvement in transport network. I've been citing some examples on how the users how the data could be used. I have pointed out clearly what overseas jurisdictions are doing. They were able to pinpoint exactly where CASA will stop suddenly and so on. So, well, you've been very clear in pointing out which parts of the question has not been answered. Secretary, I can answer that. There is another thing, what we call the smart lampposts. There will be sensors. Let me tell you now, the sensors or the detectors will be installed, and real-time information, traffic information, will be gathered. So on the number of vehicles, their speed, and so on, and the traffic condition information on all those aspects can be collected and analyzed. And in Hong Kong, there are different apps already available, and the THB has been making use of these apps already. So we can even make better use of such existing apps. The lampposts can also tell you information on the number of vehicles being parked, which vehicles are passing through this location, and whether they're traveling at a lower than normal speed. All this information can be collected. So we can achieve this goal with using software, hardware, and also the big data. Mr. Jonathan Ho, please continue. Thank you, Madam Chair. I have a simple question. The Secretary, would you be asking, say, the Energizing Kowloon East to convert information into API and share it with other relevant parties? They are now developing their own apps, and sometimes I drive and I have to switch from the map to the apps, and then that is quite dangerous, and I don't want to run into any kind of accidents. So I don't want government departments developing their own apps. That will be a problem. So from a practical point of view, can you do something? Maybe it's better, say, to show information through billboards rather than developing their own apps, just like what they're doing in Singapore. Now, the Smart City Blueprint is very much a living document, I would say. And as time passes, we will be adding on new features. And as far as energizing Kowloon East is concerned, a lot of the information is being included in our big data database, although it's not 100% included. And you talk about apps. Well, apps, there will be changes to apps as well. The THB will be combining 3 apps together into one mobile. So that's very much of the change process. Mr. Ho, he has misunderstood my question totally. I'm asking how the government will disseminate information collected to people, say, for example, drivers. How are you going to disseminate information? And you are now doing it by developing your own apps to publish information. There will be independent EKEO apps telling people how many car parks are there in Kwun Tong. That's a very dangerous approach. Secretary, do you have any supplement? Yes, I do. I'm talking about the government publishing information, how it is doing that. Other people or parties can directly access such information from the big data platform, and it will be available in the machine-readable format. So you can directly access information and do your own analysis. You don't need to count on the government to do analysis for you. Different users have different usage of the data, and we're encouraging different commercial modus operandi. And we hope that more data will be made available. 2 more members would like to follow up on this subject, but we've gone, that already takes up 22 minutes, so please follow up them on other occasions.
政府法案首讀。
Government bills. First reading.